Mr. Amos lost the lawsuit. Another more recent case involves workers for World Vision, Inc. World Vision, Inc. is a humanitarian company or organization. They are technically religious in nature, but they're not affiliated with any church or denomination. And what they do is they provide relief around the world, and relief in terms of food and water and shelter and clothing. They don't have a missionary function. Instead, they're simply providing humanitarian relief around the world. Well, Mr. Spencer and a couple of his co-workers were employees of World Vision, Inc. Now, World Vision, Inc. requires its employees to not only be Christian, but to believe in the Trinitarian version of Christianity, the Father, the Son, the Holy Spirit. And Mr. Spencer had joined the Unitarian Church. Unitarians are Christians, but they believe that there's no division between God and Jesus, that they are united. That's the name Unitarian. Well, World Vision, Inc. says if you don't believe in a Trinitarian version of Christianity, whatever that is, you can't be an employee. And Mr. Spencer and his co-workers are terminated. They've lost their jobs. Nothing to do with job performance, nothing to do with LNDRs or BFOQs, simply that you're not a Trinitarian Christian. You're not the type of Christian that we want to hire, even though our function is not tied to a church activity. Again, this case goes to the appellate court out in California in the Ninth Circuit. And the appellate court, again, because they are hesitant to define what is and is not a religious organization, sides with World Vision, Inc., and again permits this organization to discriminate on the basis of religion. There's another exemption for churches that churches have, and that's called the ministerial exemption. So this is the third way now that religious discrimination differs from the other types of discrimination. The ministerial exemption prevents interference with church employment of ministerial personnel. What does that mean? Anyone in a ministerial role, if their job is to act as a minister would act, in those cases, the employer, the church, can discriminate not just on the basis of religion, but can discriminate on the other bases of Title VII. Race, color, sex, national origin. Now, there aren't any cases involving discrimination on the basis of race in terms of the ministerial exemption, but there are numerous cases having to do with sex that we find that if the Catholic Church wants to hire men only as Catholic priests, it is permitted to do so because of the ministerial exemption, because the church has a right to decide what types of individuals should fill those ministerial roles. So that's why it is that the Catholic Church can discriminate against women in terms of becoming Catholic priests. You may be the most educated, best prepared female. You may have your PhD in divinity. You may have studied in seminary for many, many years. Nevertheless, you can't be a Catholic priest simply because the ministerial exemption permits the Catholic Church to discriminate on the basis of religion. In this case, it involved a woman, Miss McClure, who worked for the Salvation Army. And the Salvation Army is a religious organization. It's a religious organization that models itself after a secular military operation, hence the name Salvation Army. And there are ranks within the Salvation Army. There's sergeants and lieutenants and captains, And Miss McClure was a lieutenant in the Salvation Army who had applied to become a captain, a promotion, and was denied. And she was denied in large part because she was a woman, that there was clear sex discrimination that took place in this decision not to promote Miss McClure. And so Miss McClure brings a Title VII claim, sex discrimination claim. I did not get the promotion solely because I was a woman. That's her allegation. The Salvation Army defends by saying it is not a church, but it's similar to a church, and its officers perform a similar role to ministers or pastors or priests in other religious organizations, and therefore it is entitled to discriminate on the basis of sex because of the ministerial exemption. And once again, the court, reluctant to interfere with church affairs, permits the Salvation Army to discriminate, allowing the lawsuit to be dismissed because the ministerial exemption prevents any liability. We don't even get into the question of whether sex discrimination occurred. Instead, the case is ended prematurely by saying this is a ministerial role, and therefore the court has no control over the choice of ministers. So that's another big difference between religious discrimination. Now, religion can serve as a BFOQ. Title VII permits religion to be a bona fide occupational qualification. And in fact, the BFOQ for religion is one of the largest BFOQs, meaning it is widely permissible to require specific church membership in order to work at the facility. This is why educational institutions are eligible to employ those people of a particular region. Before taking the job at OSU, I interviewed at Baylor Law School, and I was always shocked. I'm still shocked when I think back that when I went in for my interview, the very first question was, "Are you a Christian?" And I thought, wow, this is really weird. Here I am for an interview for a law professor position, and the first thing they want to know is, am I a Christian? But I knew that religion can serve as a BFOQ, and that Baylor has the ability to require their faculty to be Christians. So religious BFOQs are very broadly interpreted. In this case, Pyme versus Loyola University of Chicago, Loyola is a Jesuit institution, a Catholic Jesuit institution, and Jesuits are in a particular order of the Catholic Church. They're known for their long history. They are the most educated of all Catholic priests. It takes 17 years to become a Jesuit priest. And Mr. Pyme worked at the university, Loyola University, in the philosophy department, and he was an adjunct professor, meaning he was not on the tenure track. In academia, there's really always these two different types of professors, those on the tenure track and those who are not. And a tenure track position became available at Loyola. And Mr. Pyme, who was already teaching there in the philosophy department, had good evaluations, had good research skills, applied for the job. The university, however, said that Loyola University is a Catholic institution, and we must retain its Catholic Jesuit heritage. Therefore, we are going to require this hire to be a Catholic Jesuit priest. The only people that we are going to accept as applicants for this position are Jesuit priests. And therefore, Mr. Pyme lost his ability not just to work there, but to even apply for the job. And so he brought a lawsuit, again, saying this has nothing to do with religion, that this is an academic job in teaching philosophy, a non-religious course, and I'm being discriminated against because I'm Jewish and therefore cannot even apply for the job. The court sided with the university, saying that it has this connection to the Catholic Jesuit Church, and therefore its requirement that a number of its philosophy professors be Catholic Jesuits is permissible.